Today we are going to be looking on question number 5 on November 2016, and I'm working with CASNEB revision past papers. So we are going to read Advanced Auditing and Assurance, November 2016. We are going to read the whole question number 5, and then we are going to analyze the question. Maybe we are going to ask ourselves which topic did it come from. Then later on we can go and tackle the question as required by the examiner. So welcome. In this question, and I'm going to read the whole of the question, question 5, November 2016, it says, you are the partner responsible for providing direction to more junior members of the audit department of your firm on technical matters. Several recent recruits have asked for guidance in the area of auditors liability. They are keen to understand how an audit firm can reduce its exposure to claims of negligence. They have also heard that in some countries it is possible to restrict liability by making a liability limitation agreement with an audit client. That's the end of the question. So the required part is A, discuss the civil liabilities of an auditor under common law. That is 12 marks. And B, assess the potential implications to the audit profession of audit firms that signs a liability limitation agreement with their clients. That is 8 marks. So total is 20 marks. So as you can see, it's not that long question. Somehow, I prefer long questions because, as I had already explained, they require you to go ahead and collect so many points from the details. So what we are going to do, we're going to read the question again. This time, we need to pick a number of points that will tell us which topic does this question come from. This will be my area of putting the solution. This will be my area for analyzing that particular question. So let me first of all do the analysis. You are the partner responsible for providing direction to more junior members of the audit department of your firm on technical matters. So we are told in this question that you are an audit partner. An audit partner. Remember, in quality control, there is something we call direction. So in this question, they say you are giving direction. And you are giving direction to your junior staff. They say you have what? Junior members. Junior members. So you are giving them advice on what? Technical matters. Several recent recruits have asked for guidance in the areas of auditors liability automatically. Now you know the question is about what? Auditors liability. So you come here and you say the question is auditors liability. There. Because we are discussing the auditor's liability, then you have to go looking for maybe details within your mind to remember maybe what you had covered under the liability. So they say they are keen to understand how an audit firm can reduce its exposure to claims of negligence. Do you know how an audit firm can reduce exposure? That one is called safeguards to auditors' liabilities. To auditors' liability. And I know you know this particular part. For example, we say an auditor should comply with auditing standards and guidelines. An auditor should put a disclaimer. An auditor should go ahead and ensure. Those are the points that we had maybe discussed in our topics. Then they go ahead and say they have also heard that in some countries it is possible to restrict liability by making a liability limitation agreement with an audit client. So among the safeguards, you can go in a company and restrict liability. Restrict a liability using what we refer to as a liability agreement, a liability limitation agreement. This one is almost similar to the capping of the liability. But if you go to the Kenyan Companies Act, you realize that they have mentioned that particular item and they have discussed about how to restrict auditors' liability using the auditors' liability restrictions agreement and maybe the procedure that's supposed to be followed. That's provided for in the Companies Act. But I go to the details of the question whereby they say, discuss the civil liabilities of an auditor under common law. Civil liabilities of an auditor under common law. What I'm going to start up with here is discussing what we know as civil liability. The civil liability case is very simple because we are looking circumstances where an auditor can be sued not by the prosecutor or by the state, but now this auditor is being sued by the third party or any other person. Remember, when we are discussing about civil liability, we talk about generally two types of liability arising from civil liability. One of the main liabilities is called civil liability under the law of contract, and the other one is called civil liability under the law of tort. But those two liabilities are not the only liabilities in auditing. We have an additional liability called the Auditors Liability under the law of public law, or what we refer to as criminal law. In criminal law, the auditor is going to be sued by the state. It is the state versus the auditor. The auditor becomes now the what? The person who is supposed to be defending himself, that is the defendant, and then the state becomes the plaintiff. In this case here of civil liability, we don't have the state. We have now the auditor himself being sued by third parties, and not only the third parties, can also be sued by the company itself. So here we're introducing now the civil liability in this particular case. So we say, remember, there is one, civil liability under law of contract, and there is civil liability under law of tort. Civil liability under law of tort. So before I move to tort, which is mostly the common law liability, we can first of all mention something under civil liability under the law of contract. If you are an auditor and you are exposed to civil liability under contract, we say under contract law or under law of contract, then it means there is someone who has a contract with you. Remember, we usually say an auditor does not have a contract with the third party who appointed him. So if an auditor was appointed by the shareholder, you can never go saying the auditor is supposed to be liable to the shareholders. That cannot work. We usually say because a company has what we call a legal entity, a company can sue and can be sued. So therefore, when the company enters into contract with the auditor, then the company can sue an auditor under the law of contract because the auditor has breached those particular terms in contract. So we are bringing that element here. The element here is very simple. We say only persons with the contract or with auditors, and auditors have contract that can sue an auditor under civil liability under contract. And that is what? The company that is maybe being audited by the auditor. But in order to prove that you have a liability with the auditor and that liability to be successful as a company, you must prove the following. Prove, one, that there was a contractual relationship between you as the company and the auditor. In most cases, that one is expressed in terms of an engagement letter. Prove that there was a contractual relationship between auditors and the client company. That's the rule number one, that you must prove. If you are a company, prove there was a relationship between you and the auditor. And that relationship is mostly provided by the engagement letter. So if you find an engagement letter whereby the auditor had signed and the management of the company had signed, then you can say there was a contractual relationship between the two parties. Now, number two, once you establish there was a what? A contract, the next thing is to identify whether there was any breach of terms. But before that, you say the auditor owed this particular person, that is maybe the party in the contract, a duty of care. Prove that an auditor owed the client a duty of care. A duty of care. We usually say it's upon any person in the contract to go ahead maybe and fulfill the terms of the contract. So you're supposed to implement the terms of the contract. Failure to implement the terms of contract will be referred to as breach of the terms of the contract, and that can result to the auditor being sued or the person in the contract being sued by the other party. So what you need to prove, number three, is prove that the auditor breached the terms of the contract. There was a breach in the terms of contract. So if you can be able to prove that there was some terms and conditions in that contract and the auditor did not perform. For example, you can say the auditor was supposed to have counted the stock in that company. The auditor did not, so he was negligent. So we say if you can prove that the auditor has breached the terms of the contract, then that is another way of preaching or saying that the auditor has been negligent. Prove that the auditor has been negligent. That is point number 3. Point number 4, we can say, can you be able to prove that the auditor knew the purpose for which the report was being measured or prepared for? The auditor knew the purpose of the report. Purpose of the report. But apart from the auditor knowing the purpose of the report, can you be able to prove that the third party suffered a loss? Because we can only compensate a loss. A loss must arise because you're suing under civil so that you can be compensated. Prove, number 5, that the company or the client company / client suffered a quantifiable or a quantifiable financial loss. Financial loss. So if you can prove these 5 points here, then automatically you will succeed very well against the auditor who has committed any of that particular type of what? Of a crime. So not a crime, but maybe a breach of contract. So if you are an auditor and you know that you have a contract with any other party, then automatically that party can bring a lawsuit against you in case you breach the terms of that particular contract that you are with him. And that is the first civil liability that we talk about. The second civil liability that we talk about is this one. Civil liability under the law of tort. And I know you know tort very well because we usually say tort arises when you conduct or maybe you do something we call civil wrong. Civil wrong. And so we are looking about in this case and we're asking ourselves, what did the auditor do? But before we go to that particular extent, let's ask ourselves, who can sue an auditor under civil liability or in civil liability under the law of tort? These parties can sue an auditor under the law of tort. The parties who can sue an auditor, we can say, one is a shareholder. And this is where I want you to get your key point correctly. This one is not the shareholder. This one is a company that had employed the auditor. Even though the auditor was appointed on behalf of the company by the shareholders are not the first party. The first party is the company, and the second party or third party is the shareholder. But the shareholders are not alone in this fight. They have a person called the investors. Perhaps the investors may have also lost some money. And apart from investors, we have people like the government. The government may have lost money. For example, the income tax authority. The income tax authority may have lost money through maybe low tax that was paid due to those misstatements, or maybe due to tax avoidance arising from those particular misstatements. That's what now we want to go ahead and prove. So there are so many people, including lenders, who can sue an auditor against what we refer to as a third-party liability or civil liability under the law of tort. In this civil liability under the law of tort, the third party or the third party who is suing the auditor must prove the following. 1, prove that the auditor owed them a duty of care. That auditor owed them. By them, I mean the public or maybe the investors. That auditor owed them a duty of care. A duty of care. We say it is upon each and every person, especially any person of sound mind, to go ahead and conduct good things or perform good things to his neighbors or maybe to other people. We are not supposed to conduct a civil wrong. So if there was a duty that an auditor is supposed to go ahead and care for the public or maybe for the people who are going to be using those financial statements, but the auditor did what? Number 2, the auditor opted to breach the duty of care. Auditor breached duty of care. If you can be able to prove that one, and number 3, prove that you suffered financial losses or quantifiable losses. That third party suffered a quantifiable financial loss. Quantifiable financial losses. So if you can be able to prove that particular fact, that you suffered a loss, and that loss is quantifiable in monetary terms. And apart from that one, number 4, we say, can you be able to prove that this loss was attributable directly to the auditor's negligence? That the loss was attributable to auditor's negligence. If you can be able to prove that fact, there is one more fact that I'm going to propose, but I'm not going to write it here, but not very clearly, that the auditor owed them a duty of care, that is a public, that the auditor breached the duty of care, that he was maybe bestowed upon him by the law, that the third party suffered a quantifiable financial loss. You must have suffered a loss. And number next is that the loss was attributable to the auditor's negligence. One more point relating to this particular part of tort is that the auditor may have usually not issued a disclaimer. So if you can prove that the auditor never placed a disclaimer in his liability, then automatically you will win against the auditor. So a continuation of that point number 5 there would be, number 4 will be that the auditor did not place a disclaimer in his report. So basically, if you report those 5 major items, you are likely to go ahead and succeed against the auditor. Prove that the auditor owed you a duty of care. Prove that the auditor breached that duty of care. Prove that the third party suffered a quantifiable financial loss, or you suffered a quantifiable financial loss, and then go ahead and prove that it is out of that loss, it's out of those financial statements that were prepared by the auditor that the third party suffered a quantifiable loss, and that the auditor did not place a disclaimer in his report, maybe to warn you as you use that particular report. So as you can see, that is what we call the auditor's liability, the first part. The first part was carrying you 12 marks. So I was believing if you can be able to define the word liability under the law of contract, and then you give those particular 5 points, you're going to get full 6 marks. If you can be able to define civil liability under the law of tort, you say it is a liability that arose out of the auditor's negligence to a third party, and the third party here include even shareholders and other persons, then you can succeed by providing these particular points to that particular extent. Number 5. So I'm deleting this one, the whole of this, so that I can jump to part B of this question, and which reads, assess the potential implications to the audit profession of audit firms that sign a liability limitations agreement with their audit clients. Suppose you have signed what we refer to as a liability clause with your client. What is the effect of that on financial statement as well as to the audit firm? On the financial statement as well as to the audit firm. Usually, when you put an agreement, you are telling the auditor, your work is to that extent, your penalty is to this extent, and your money is going to be paid to this extent. So we are putting everything in an agreement. We don't want maybe to open that particular case of what? The law defining maybe how much or maybe what the auditor is supposed to be charged with. So usually, there is an agreement written when you're drafting an engagement letter. An agreement is written between the client and the third party and the auditor. And they agree on a number of factors. Those factors, one of them is supposed to be what we refer to as a liability limitations agreement. A liability limitations agreement. Liability limitations agreement. Usually, it is an agreement. That's how you define it. It is an agreement that trying to minimize or reduce the auditor's liability to any third party. So if you're suing an auditor and he has an agreement with you that you cannot compare, you cannot ask the auditor more than this particular amount, then that is the part that the auditor is going to be very happy. But if the auditors knew very well that in most cases, they have money to go ahead maybe and compensate this particular client to a particular extent, then it is going to be lowering the quality of the audit. So you say the implications of this, implications of liability limitations agreement One of them is quality. Usually we say it does not improve the quality of the audit because in most cases, the auditors know they can go without auditing and still get their money and compensate a small amount maybe to a particular company. So quality of the audit is compromised. Quality of the audit is compromised. If you have a liability agreement, you tell the auditor, I cannot pay you or you cannot pay me any amount beyond this figure. Then automatically the auditor is going to do his work in a scheduled manner and substandard work is going to be given by the auditor. In most cases we say, whenever you put a liability limitations agreement, you will find that the value of the financial statement will decline because not so many people will be relying on those financial statements. So we say decline in value of audited financial statements. So the financial statement have been audited already, but because the auditors know very well that he's not going to be having what? He's not going to be having a major liability. The liability already had been discussed. So, we can only be asked 300,000 in case of any particular problem. We have discussed to what extent are we supposed to be liable. So this one is going to decline in the value of the audited financial statement. And we can say it lowers credibility of the audit firm, of the audited financial statement. So if you're auditing financial statement and they have a liability limitation clause, not so many people will go ahead and use those particular financial statement because they know you have been compromised all through. But if we know that whenever you are taken to the court, you can be able to go ahead and pay whatever fine the court decides, then you're going to be very, very careful. And therefore, in most cases, it will not decline that particular items in value. The other thing that we have here, which is a problem in relation to this one, is reduction in audit fee. So most people will ask you, now that you have gone maybe in a particular level whereby your liability is limited, don't you think now you're not doing everything that's supposed to be done and therefore you're going to be pressured to minimize? Auditors will be pressured, to minimize audit fee. And that becomes another particular point relating to this. In other cases, you can say that whenever we have a liability limitations agreement, it also compromises on the what we refer to as competition. Not so many audit firms will be competitive. So audit firm competitiveness. I can also add another point, for example, image, the corporate image of that audit firm. Audit firm competitiveness and image will be compromised. You can imagine you are fighting with a heavyweight, someone who has a lot of money, that's the big audit firms, and you can also imagine you're also fighting with a small audit firm. So if the other big audit firms are able to acquire a client because they have ability to go ahead and sign that liability limitations agreement, then you as an small audit firm, you'll never grow. You may never grow at all. If you're not going to grow, you're also going to be discrediting your good image. That is also going to be a major problem. However, because the examiner was asking about implications, and we never knew that he was asking about positive or negative implications, we can say by having a liability limitations agreement, this one is able to defines the auditor's liability in advance. By this one I mean that most of the auditors will be able to know what are their problem in advance and be able to tackle that problem as early as possible.
Thank you for watching this video. Don't forget to get yourself a copy of our professionally prepared study text and revision partners. Visit our shop along Tom Boyer Street, Pioneer House, 3rd floor, opposite Fire Station.